So again, a very warm welcome to all of you joining us for today's session. It's entitled Qualification of Situations, Case Studies from Recent Practice. And today we'll be discussing the Ukraine and Syria and going through with our two experts how one qualifies these rather complicated scenarios. And it's not just the exercise of qualifying these situations under IHL, it's also intended to be a discussion about the practical relevance of undertaking this exercise. So it's not just an academic exercise, it's a very important analysis that takes place with very real consequences for those in the humanitarian field, as well as other fields, for instance, states, military, etc. So we'd like to just go over our learning objectives briefly before beginning. And these learning objectives are useful because we like to be accountable to you, our participants, in terms of what we cover in our sessions and what we hope you are able to gather from the session. So today we hope to facilitate an understanding of how a qualification is actually undertaken. So that sort of the methodology and the step-by-step process of what undertaking a qualification analysis looks like. We hope that people will walk away with a familiarity with both the terminology and the rules so that when discussing qualification, one is well informed and using the relevant rules and vocabulary correctly. We hope that there's an awareness of the different criteria that might be helpful in determining when a threshold has been met. It can be very tricky to figure out when IHL actually applies. When is there an international or a non-international armed conflict? And there's indicia that have been provided in jurisprudence, in the commentary to the Geneva Conventions. And so we'll look at some of these criteria that can be helpful in assessing whether or not the threshold for an international or non-international armed conflict has been met. We hope that you will develop an ability to analyze what can be rather complicated, tricky scenarios, and also those that are developing rapidly, very much like the Ukraine and Syria. And finally, we hope to facilitate an appreciation of both the practical utility and the relevance of undertaking such an exercise. So with that, I'm very pleased to introduce our guest speakers. We have Sareta Ashraph with us, who is a chief analyst with the United Nations Commission of Inquiry on the Syrian Arab Republic. And we have Laurie Blank, who's clinical professor of law and the director of the International Humanitarian Law Clinic at the Emory University School of Law. And so we will be turning first to Laurie, who will take us through the qualification of the Ukraine, and then to Sarita. And we will allow for some brief Q&A after each presentation. So that will have Laurie presenting with Q&A and then Sarita presenting with Q&A. And I'd like to also remind those of you who are interested that there will be an assessment available after today's session. And with that, I think I will turn it over to Laurie to speak with us about the Ukraine.
Yes, hi. Thanks very much. I'm very happy to be here with all of you. Just making sure the systems are all working here. So, as Beth said, I'm going to talk a bit about classifying the conflicts in Ukraine. And I think we have three, the Ukraine offers a great example to walk through three types of conflict. So in that sense, it's really a very useful learning exercise for us to think about both how to look at different types of conflict, how they might interact, how we might see the layers of international law and of course domestic law that are going on here. So it's quite interesting to look at these. I want to start just by saying that in many cases we'll see an instinct oftentimes when we listen to people talk about whether there's a conflict, whether there isn't a conflict. You'll often find sort of an instinct to just find conflict immediately whenever there's any kind of unrest. Or, among others, you might find an instinct to have a very high threshold. And I think we want to be careful to really stick with the way the law wants to view this, which is that this is an objective analysis. There are reasons why we have certain thresholds for international armed conflict, for non-international armed conflict. And, we need to remain objective in looking at these. So let me move us to the next slide, which, there we go. Sorry. So again, we're going to end up covering 3 types of armed conflict in this discussion of Ukraine. And again, that's why it's so useful. We'll look at international armed conflict. We'll look at non-international armed conflict and also occupation in order to see everything that's going on. And in that respect, I want to look at 3 different stages of what's been going on in Ukraine since February of 2014. And I'm going to be, in the interest of time, I'm going to be quite short in talking about facts. So those of you who I know far more about the specific details of what's been going on, many of you have worked in that situation. Forgive a very brief discussion of facts because I'm really using it to talk about the legal issues. So we have 3 stages. We have the protests in February in Kiev. We have the situation in Crimea, which was late February and into March of 2014, and obviously that continues. And then we have the drawn-out conflict in eastern Ukraine that began in the spring, late spring, early summer of 2014 and continues to this day. So those are the parts we're going to go through. Now, let's look first at international armed conflict. International armed conflict refers to conflicts between 2 states. In order to have international armed conflict, you have to have a state on each side of the conflict. And so the threshold, the application standard for international armed conflict is set out in Common Article 2 of the Geneva Conventions. That means it appears in all 4 of the Geneva Conventions. And you have this here on the slide in front of you. All cases of declared war or any other armed conflict between 2 or more of the high contracting parties, even if it's not recognized by one or even both of them. As you know, the Geneva Conventions are ratified by all states, so we don't have to look at who has become a party or not. When we look at the question of where we have international armed conflict in Ukraine, we're going to look at Crimea in February, March of 2014. Now, we want to remember here that international armed conflict has a very, very low threshold. And in essence, anytime we have the armed forces of 2 states that are engaged in a dispute between those states, we're going to hit that threshold. So if we look at what happened, we had Russian troops, albeit without insignia, but Russian troops coming into Crimea in late February, early March 2014, and there were no hostilities. I believe maybe a few shots fired here and there, but in essence, no hostilities. But once they were in Crimea without Ukrainian consent, and certainly taking, in essence, using force by being there, right, and forcing Ukrainian soldiers to stay in their barracks or eventually to withdraw, you have international armed conflict. You do not need to have shots fired in that situation. Why is this? This is to maximize IHL's protective purposes and ensure that there are no gaps, that you don't have a situation where you have some low-level fighting between 2 states, but no law that can protect people in that situation. Now, you also want to remember that it doesn't matter what the 2 states say, what their rhetoric is in terms of either why there is this engagement going on or whether there is an armed conflict going on. The very purpose of the Geneva Conventions in defining armed conflict in this way was to ensure that it would be an objective analysis of the facts on the ground and not based on what one state says or another state says. So that's the situation in Crimea in February, March 2014. As soon as you have the Russian forces there without consent, you have this very low threshold of international armed conflict that is met. Let me move on to occupation, which is the next piece of the puzzle here in Ukraine. Now, occupation, the law of occupation stretches back to before the Geneva Conventions, and we see some early glimmers of the law of occupation in the Lieber Code, which was the code of conduct for Union forces in the Civil War here in the United States. That's where I'm speaking from. I know you all are all over the world. But we really start to see the law of occupation laid down in the Hague Convention of 1907. And I've just listed here some of the articles if you want to go and look at them. In the interest of time, I'm not going to, detail. But in essence, the law of occupation focuses on a situation where one state begins to exert control over the territory of another. You see the need for legal parameters for the conduct of those forces, for the protection of civilians. That becomes very strong indeed. And one way to think about the obligations of an occupying power, which we won't get into today, we're really going to focus on the existence of occupation. But one way to think about those obligations is to think about what's called humorously the Pottery Barn rule, which is if you break it, you own it. Those of you who ever shopped in a store like that, you know what that's all about. The idea is that once a power has become an occupying power, they are responsible for all facets of society, maintaining law and order, providing for the public welfare, justice, medical care, health care, etc. They are responsible. The occupying power is a caretaker. Their job is to preserve the status quo, preserve the welfare of the population, the administration of law and order and justice, in order to then turn it back over to the occupied state at some point. Occupation is not about annexing or absorbing that territory at all. That is prohibited under international law. So if we look at Crimea in March 2014, the first thing that's really important here is that there was no armed resistance. This lack of armed resistance does not prohibit a finding of occupation. And if you look at the text of Common Article 2 of the Geneva Conventions, you'll see that armed resistance is irrelevant. A country can occupy another's territory without any fighting at all. In addition, the fact that there may have been consent from the local or regional authorities in Crimea is also immaterial because Ukraine was the sovereign power, and that's where any consent would have to come from. So, how do we know that we see occupation? We look for effective control by the occupying power. The way the Hague Convention of 1907 defines it is that territory is actually placed under the authority of the hostile army or the hostile forces. In general, we want to see that that power is established and can in fact be exercised. So if you have intensive fighting going on between two states and that foreign power is not able to exercise control, you would not have occupation because they're not administering the territory or anything like that. So let's move on to the next slide. So if you look at what happened in March 2014, you see once the Russian forces came in, you see a displacement of the governing authority. You see effective control as very quickly the Ukrainian forces withdrew. It doesn't matter that there was no armed resistance. And you see the exertion of effective control by the Russian forces. Now, the nature of Russia's justification is irrelevant because we separate the lawfulness for the resort to force, which is the reasons why a state is going to war and going to use force. That's called the jus ad bellum, the law governing the resort to force, which is self-defense or a UN authorization, things like that. We separate that from IHL, which is the law regulating the conduct of hostilities, the protection of persons, and in this case, occupation. So it's important to note that it's really irrelevant, Russia's explanation, whether they're considered legitimate, illegitimate, whatever it is, that doesn't bear on whether or not there's occupation. So let's move on. I want to make sure we have enough time to cover everything. If we move on to non-international armed conflict, here I want to look at two stages of the situation in Ukraine. And the first thing, just to get everyone here on the same page, is to note that very important, the difference between international armed conflict and non-international armed conflict in terms of the threshold for application. So I talked earlier about the fact that there's an extremely low threshold for international armed conflict. That's a conflict between two states. There's a reason for that low threshold, which is that in the absence of any protections, any parameters and paradigms for legal protection under IHL, we would have a gap without any law to govern the relationship between those two states and their actions. Well, non-international armed conflict is different. Non-international armed conflict refers to a conflict between a state and a non-state armed group, or between two or more non-state armed groups. And so we are not talking about two states fighting against each other. We're talking about one state and then non-state entities. So we have a different threshold here. At the time NIAC, non-international armed conflict, was introduced into the Geneva Conventions in 1949, there were great concerns for state sovereignty, for legitimacy in terms of these non-state groups that were fighting. And we see that there's a need for the state, which has sovereign control over its territory, to be able to exercise its own law and order security powers to handle unrest, riots, low-level disturbances. We don't want to have international law just jump in the moment that there is any violence or unrest. That would be an interference in state sovereignty. By the same token, there's a point at which violence reaches a level at which we need to have the protective components of IHL to step in to the situation. And here I should just add something I didn't state at the beginning, which is that it's important to note, you'll see this balancing always going on with IHL. Where do we find the threshold? How do we apply the law? This is because IHL is about both obligation and authority. From the humanitarian perspective, we think about the obligations of IHL and the need to protect people, to regulate the use of force during hostilities in order to protect civilians, to protect those who are hors de combat, and so on. But it's important to keep in mind that IHL is also a law of authority. And this is the authority to engage in military actions. And this is based on the principle of military necessity. And so during armed conflict, parties to that conflict can use force as a first resort against enemy personnel, can detain enemy personnel without charge for the duration of hostilities. This is very different from peacetime, as you all know. So it's important to keep in mind that balance. So when we look at non-international armed conflict, we have two types of non-international armed conflict to consider. Common Article 3 of the Geneva Conventions is the initial statement of law governing non-international armed conflict. It doesn't really give us a definition. It simply says armed conflict not of an international character occurring in the territory of a high contracting party. We can also look at Additional Protocol 2, which is an additional treaty, 1977, that sets out more rules for non-international armed conflict. And here, a couple of additional components that make a higher threshold for an Additional Protocol 2 conflict. Government forces must be involved. You cannot have a conflict simply between two armed groups. And the non-state armed group must exercise control over part of the state's territory, operate under responsible command, and have the ability to carry out sustained military operations. So we're going to come back to this in the context of Ukraine. And I'm just going to look at my time here. Okay. So when we try to identify the existence of NIAC, what we look at is based on the jurisprudence of the International Criminal Tribunal for the former Yugoslavia in the Tadic case, which fleshed out the meaning based on Common Article 3. We look for protracted armed violence between the government and armed groups or between two or more armed groups. How do we identify this? We look at the intensity of the fighting. We look at the organization of the non-state group. Are they organized so that we can identify the other side? If you think about the idea of needing two sides to a conflict, you've got to be able to identify that other side. It's also useful to look at how the government is responding to the situation. Are they using the military, or do they feel that the police is sufficient to handle this situation? So first, let's look very briefly at the protests in Kiev, where we have our first question of armed conflict classification. And we can look at whether or not the threshold for NIAC was met. And we had significant violence, over 100 people killed, I believe, and violence for several days. But I think the general consensus at the time, given the brevity of it, was that the non-state groups, the protesters in essence, were not really organized in the way we might I imagine a non-state group, an organized armed group as we think about it, to be sufficiently organized. In addition, the government did not call out the military, stuck with the security police services, and I think at the time it was close. It was right there at the edge, perhaps, certainly could have transformed into a NIAC, but I think the general consensus was there was no NIAC. We might have certainly had enough intensity, but we did not have that organization, and the government certainly was not responding in a way that might make us think about a NIAC. And I'll suggest that you keep that in mind when Sarita talks about Syria later on, because there we see a big difference. Let's quickly move into Eastern Ukraine, where things get interesting. I think we can skip ahead of the question of intensity and organization. We have organized separatist groups. We have heavy fighting going on. We can certainly say that by early summer, we have a NIAC. But now the question is, what do we do in terms of the involvement of Russia? And does that change the situation? So let's look at a couple different ways of looking at this. The facts are certainly a little hard to get a handle on, lots of different information. Couple of ways to look at this. First of all, if Russian troops were directly involved, which I think there's a lot of evidence of this, if they're directly involved in the fighting in Ukraine, in eastern Ukraine, then we have international armed conflict between Russia and Ukraine. Now let me come back briefly, and let's remember the fact that there's occupation in Crimea. Well, if you have an occupation in Crimea, you have an international armed conflict between Russia and Ukraine, because occupation is a subset of international armed conflict. So let's keep in mind that overall, we have this international armed conflict, this state of international armed conflict already existing. But let's focus in on eastern Ukraine and look at the involvement of Russia. If they're fighting directly, Russian troops, then I think you don't have to assess whether or not Russia's level of support for the separatist group, because they're directly involved. Now, let's look at a different question. What if Russian troops are not directly involved? As Russia says, we want to look at the level of overall control that Russia has over the separatist groups. This is the test, again, laid out by the ICTY in the Tadic case, to try to determine if a state's involvement in a NIAC is going to transfer it into an international armed conflict. There we look at evidence of overall control. Do they have shared personnel? Do they have is the state giving orders for military operations, troop movements? Are they paying salaries? And so we see a lot of evidence of that as well, in terms of Russia providing extensive military equipment and supplies. They seem to hold the decisive war armistice talks.
We seem to have a connection problem. You can't hear me either? So it's our connection.
Are you all able to hear me?
This is Beth. Yeah, I think the connection's okay. Yeah.
Okay. So let me just wrap up here. Let me wrap up quickly, because I want to get to the consequences of this. Why does classification matter? Now let me just point out, last point here on eastern Ukraine, is that we very likely have two conflicts. Now, NIAC between the government of Ukraine and the separatist groups, and an international armed conflict between Russia and Ukraine. In order to have those wrapped into one international armed conflict, we'd want to see that the separatist groups are belonging to Russia. And again, I at least don't have enough of the facts to be able to make that determination. And I think that may be the case, but it would depend on whether or not they, in essence, belong to Russia. They're fighting for them in such a way that they're, in essence, part of the Russian forces. So we have some uncertainty there. Now, just to get to our last point here, why does this all matter beyond, you know, the fun of thinking it through in the classroom? See if I can get us to our last slide. There we go. Why does classification matter? Well, the nature of the obligations, obviously, if we have conflict versus no conflict, very different. I think you all know that, so I don't want to spend too much time on that. I want to focus on the status of persons. And here's where things can get very interesting when we look at what is the status of persons. So quickly, 3 categories of persons here where the difference between conflict matters. We have, quote, the little green men, which are the Spetsnaz commandos and other Russian forces who came into Crimea without any insignia. We have the Ukrainian military, and we have the separatists. And in order to think about their obligations and their protections, it matters whether we have international armed conflict or non-international armed conflict. In international armed conflict, we have POW status for government forces. In non-international armed conflict, we don't have that. So, for example, let's look at one example before we move on to some questions and to Sarita, because I know we're running out of time. The Ukrainian pilot who was captured by separatist forces in Ukraine and transferred to Russia. This encapsulates many of the issues. If there's an international armed conflict between Russia and Ukraine, which I believe there is, then she would be entitled to POW status. And she would only be able to be tried in a Russian military tribunal for violations of IHL. We have something going on in terms of her actual treatment. Now, if it's a non-international armed conflict and Russia is not involved, then she's detained as a civilian under Russian domestic law, and we would not have rules governing the transfer from the separatist group to Russia, and she would be able to be tried in Russian domestic civilian courts. So I'll let more issues come up during the Q&A because I want to make sure we leave enough time, but that highlights some of the questions which arise when we think about classification. So Beth, I'll turn it over to you for some Q&A. Thank you.
Great. Thanks so much, Laurie. And we have a number of very good questions coming in. The first I'd like to move directly to Sarita, and Sarita will now walk us through the sort of qualification assessment for Syria. So Sarita, are you with us? Yes, sounds great.
Just going to bring up the slides now. Hi everyone, I'm the analyst on the Commission of Inquiry on Syria, and as Noel last week and Laurie's just gone over the legal aspects of qualification, I'm going to kind of move through this quite quickly and really speak about the factual and legal analysis that the Commission of Inquiry on Syria went through and continues to engage in respect to the classification of the Syrian conflict. So just a little bit about the Commission of Inquiry, for those of you that don't know. It's been running since August 2011. On the slide, you can see 2 of our commissioners there, the chair, Paolo Pinheiro, and Karen Abuzaid. And we have a mandate to investigate all violations, all alleged violations of international human rights law since March 2011 in the Syrian Arab Republic. That was slightly adjusted in October 2012 when it, by the HRC Resolution 2126, which went more broadly into investigations into abuses and violations of international law. I should say, however, that the Commission has a power to interpret its own mandate, and so from prior to October 2012, we were looking at IHL. It's very relevant, the classification of the conflict, evidently. Laurie's spoken a little bit about that, but for the Commission of Inquiry, it's particularly important that we are documenting violations of international law in respect of the applicable legal regimes. And assessing which regime applies in any particular situation in Syria is critical because different standards and rules apply. So, for example, in the initial stages of the unrest in Syria, when you had allegations of the government firing on protesters, At that stage, it would have been quite preemptive to start bringing in IHL rather than using human rights standards, which restrict the use of lethal force. So, whereas in conflict, there is the use of lethal force between belligerents is obviously permissible, based on boundaries within IHL itself. As part of our determination, we make a public determination of when and if violence in Syria passed into the threshold of an armed conflict. Now, as Laurie said, there's no one arbiter of when a classification occurs, but the Commission of Inquiry, because it's an ongoing conflict, and the Commission is gathering a tremendous amount of information and making those, it's very relevant, I think, to the political and legal discussions around the conflict. And it's a very important determination, partly for this issue of accountability. So we have already seen now in some of the national trials that have been taking place, mainly in Europe, that the issue of when the conflict passed into being an armed conflict from unrest and from violence has been very relevant in arguments that the defense and prosecution have been having over indictments and when, for example, war crimes can be charged. So it's a particularly important thing. Now, I'm going to skip over these two slides because I think they've been covered by Noel last week and Laurie this week quite quickly. In terms of Syria, as you know from last week, there are two types of NIAC, but Syria is one relating to Common Article 3 of the Geneva Conventions, the other in relation to Additional Protocol 2. Syria is not a party to Additional Protocol 2, and so it takes that out of the running. The ICTY jurisprudence, as we've heard, has been tremendously informative in terms of laying out when a NIAC comes into existence, and the Tadic decision in October, 2nd of October decision, speaks about protracted armed violence between governmental authorities and organized armed groups or between such groups within a state. However, I would really advise people to continue to look more at ICTY jurisprudence, and particularly perhaps the 30th of November 2005 judgment in the Limage case, which really goes into much more detail about how you assess the intensity of a conflict and the organization of armed groups. So let's talk a little bit about Syria. In Syria, as everyone probably knows, protests started, well, there were some protests in February, but more organized protests erupted in mid-March of 2011 in Dara in response to the detention and torture of a group of children who had painted anti-government graffiti on public buildings. The protests were suppressed by the government, including the firing on a funeral procession of one of those children, a 13-year-old boy called Hamza. And the protests spread rapidly to other governorates, Damascus, Homs, Ham, and Idlib being really taken up with protests. I think this actual picture that's on here is from Homs in July 2011. The government, initially the protests were not calling necessarily for the overthrow of the regime. The earliest protests were calling for political reform, largely, although it came quite quickly to calling for the overthrow of the regime. Quite quickly, by the 25th of April, there were military operations ongoing into Dara, and you had tanks entering Damascus, Homs, and a couple of other governorates by May, with access points to the towns and cities being sealed. There were quite a number of casualties. By November, in fact, I think OHHR had set out a statement that 3,500 people, civilians, had been killed in the response to crackdown on the protests. At the same time, there was, well, not at the same time, but very early on in March, between March and August, you had mass defections from the Syrian armed forces. There were large numbers of defections, although not in the central core of the armed forces. Additionally, you had armed groups, localized armed groups being formed and civilians joining their ranks. So you had a mix of defectors and civilians, but at a very local and quite fragmented level. On the 29th of July in a television, 29th July 2011, on a television address, defectors from the Syrian army announced the formation of the Free Syrian Army, or FSA. And there began to be attacks on government forces, but there was very little understanding at that time about the size, the structure of the armed groups, their ability to mount military operations, and indeed the relationship between people on the ground and what they call themselves the leadership in Turkey, or the Free Syrian Army. So there was a period of time where it was quite difficult actually to work out how the armed resistance, how the protests had turned and had clearly become less and less peaceful. And in fact, by August 2011, there weren't very many what you call peaceful protests going on, but still it was unclear the extent of the organization of the response to the government forces. So the Commission released its first report on the 23rd of November. Bearing in mind the Commission had been in operation since August. And that covered the period from March till November 2011. And one of the key things that the Commission looked at, because we were trying to determine the applicable legal regimes, was had the violence in Syria, had it crossed the threshold to being into an armed conflict, and would therefore we be using IHL as a legal regime to assess what was happening rather than simply international human rights law. And I've set out there on the slide the Commission's reasoning. And we refer explicitly to the Tadic judgment. And we were unable at that time to verify the level of the intensity of the combat between the armed forces and armed groups, and also the level of organization of groups such as the Syrian army. And so for that report, in fact, IHL was not used to assess what was the violations or abuses of international law happening inside Syria. I'll move on to the next slide. Sorry. Between January 2011 and January 2012, it was a very important time, I think, in the Syrian conflict, and it was also very difficult still to work out what was happening. And this is why I think it's important to stress that the movement of a situation from unrest and violence into armed conflict is never a clear line. It takes a tremendous amount of information to work out when that happens, and I don't think you ever find the exact time. And that's why, especially if you do it in real time, as the Commission inquiry is, it becomes quite a challenging situation. It's much easier when you're in an international tribunal 10 years later to work that out. But nonetheless, there was a tremendous amount of effort and resources put into trying to work out how to classify this armed conflict. And it became quite clear over that time period, the conflict had become increasingly violent, increasingly militarized. We were seeing, for example, a rise in the number of government forces that had been deployed to respond to armed factions that had risen out of the protest movement and out of the defections. We had seen the government employing a very military response, which suggested that they no longer considered that the violence could be contained within the framework of a law enforcement campaign. We also saw an increasing number of casualties and destruction of property, looking at more of a collective nature of the hostilities was coming into being. And of course, there was a growing number of people who were fleeing Syria and were crossing the borders to become refugees, mainly in Turkey and Jordan, which was, again, suggesting to us that the geographic scope of the violence had spread and the violence was becoming more intense and more protracted as people were choosing to leave their homes and become refugees. In December, there was the Arab League had a peace plan, and there was international observers were brought in to oversee the implementation. That was suspended by January 2012 because of the scale of violence across the country, which is, again, something that points to the intensity of the hostilities that were ongoing. Yet, in trying to determine what was the structure and the organization of the armed groups, it was still very difficult by 2012 to say that there were didn't continue to be localized with a minimum level of command and control between groups on the ground. And so we came to the Commission's second classification, consideration of the conflicts classification, which happened in our February 2012 report. And there we can see there's an evolution in the understanding and in the facts on the ground, where the Commission has now said we're gravely concerned that the violence has reached the requisite level of intensity in areas, but we were unable to verify that the armed groups had reached the necessary level of organization. It was also unclear to us as part of that whether groups referring to themselves as FSA were merely using it as a brand or had been recognized by the FSA leadership or indeed obeying the FSA leadership. So when you think about the Tadic test there, it's quite interesting because what we began to see between the end of 2011 and into the start of 2012 was that it was increasingly clear from information coming out of Syria, from statements taken from refugees and people inside Syria, that the intensity of the conflict had grown, and so the issue of the threshold was really becoming a very live issue. But yet the second branch of it, which is the organization of the armed groups, there wasn't sufficient information for us to be certain that we are now pushed over the threshold. So in fact, the Commission didn't start applying IHL and stayed with the international human rights law for that report as well. In February and March 2012, we began to see much more apparent attempts to organize themselves by the FSA. So we had the creation of the Joint Military Council. Local military councils were also set up. There was much more coordinated action between armed groups, and the groups had the capacity to mount more sustained military operations against state security and forces. We're also seeing the FSA being able to recruit members and provide basic training, and that they were having more regular supplies of weapons to them. They were also engaged, and this was quite important in terms of the military analysis of the conflict. They were engaging with clashes on multiple fronts simultaneously, which is very important because it requires quite a significant level of coordination to do that, for the groups to plan that. That said, factually, it was quite clear that there were smaller groups which were not at all organized, which were many small groups working in very local situations. However, increasingly those groups are being absorbed into larger, more organized entities. And so we came now to the Commission's third classification, consideration of the classification, which happened in August of 2012 in our third report. And that covered the period from the 15th of February to the 20th of July 2012. And it was at that point that the Commission decided that the intensity and duration of the conflict, combined with increased organizational capabilities of anti-government armed groups, met the threshold for a non-international armed conflict, and so started to apply international humanitarian law. There was a very specific conclusion, and it was a main plank of this report because it was clearly a very significant moment in the Syrian conflict, both factually because it had tremendous implications for people on the ground, but also it brought in various legal obligations, in particular on the armed groups, and brought in the prospect of using war crimes as a way of looking at what we were receiving through the ambit of war crimes, international criminal law, war crimes. So there we had a non-international armed conflict developed in the Syrian Arab Republic during February 2012, which triggered the applicability of Common Article 3 of the Geneva Conventions, as well as customary law relevant to non-international armed conflicts. As I said, it's not that the Commission of Inquiry is the sole arbiter. There isn't the sole arbiter of when a situation moves into being an armed conflict, but nevertheless, around that time, there were a number of indications that Syria itself had recognized that it was now in a state of war, in a statement that President Assad made in June of 2012. ICRC, which really discusses, sets out when a state moves into armed conflict. Nevertheless, in some of its press releases in May, and then again in July statement, described violence as having crossed the threshold of armed conflict and now moved to being a non-international armed conflict. Equally, the Security Council, which again doesn't tend to make statements, in the discussions which followed the briefing in August 2012, it was apparent that the consensus within the Security Council was now that international humanitarian law was now applicable in Syria, denoting the existence of an armed conflict. Now, as Laurie and Noel said, the discussion of whether something moves into being a non-international conflict does not be an end-all, because obviously one can have an international armed conflict concurrent with a non-international armed conflict, and a non-international armed conflict can also become internationalized and become international armed conflict. So one of the things that the Commission of Inquiry did, and I think all those who are watching Syria continue to do, is to look at, is this conflict evolving, or is there an IAC that is coming into being or has come into being? And that has really involved an assessment of the nature and degree of other states' involvements in the conflict. And again, you go to the Tadic appeals judgment, which gives some insight into the control required by international law may be deemed to exist in a state or in the context of an armed conflict. The party to the conflict has a role in organizing, coordinating, or planning the military actions of the group, in addition to financing, training, equipping, and supporting them. There's in fact quite a lot of information and discussion on this, but the Tadic judgment for now is useful. And so one of the things that we continue to look at, and we have looked at in the past, is the extent to which states who are involved in backing some of the armed groups where in fact have reached a level of control where in fact their level of overall control is such that it would move the conflict to be increasingly internationalized and perhaps over the threshold into an international armed conflict. That does not appear to have taken place in Syria. Obviously, that's something we continue to monitor. But no state appears to have overall control of any of the armed groups. And so at the moment, we don't consider the NIAC to have become internationalized. I did want to point out just that it doesn't work the same way. Obviously, IAC is between two or more states. So the fact that the Syrian government, for example, may have fighting for it or on behalf of it or with it, groups under the control of another state, that doesn't alter the classification of the conflict, which remains an IAC. Finally, I want to talk a little bit about the airstrikes on ISIS, because I think this is something that has caused a lot of debate. At the moment, there's an international coalition, as you probably know, that is conducting airstrikes on ISIS in Iraq and in Syria. The question of whether that affects the classification of the conflict, or indeed whether those strikes are legal, has been very much debated in media and in some of the online legal blogs, international law blogs. As you probably know from discussions around the Iraq War, for example, that international law prohibits the use or threat of force against the territorial integrity of states, except for a number of very exceptions, which are the Security Council resolution under Chapter 7 or the right of self-defense. At the moment, as of now, the strikes on Syria on ISIS have really come as an extension of the conflict in Iraq, where Iraq's right to self-defense has a right to self-defense under the UN Charter and has requested outside assistance because it's not capable itself of engaging ISIS. And it's that request for assistance that has allowed the coalition to extend its strikes into Syrian territory, I should say coalition, to extend its strikes into Syrian territory even without a Security Council resolution. So that's the situation for the strikes on ISIS. Of course, as the strikes continue to focus on Syria and the statements of governments are much more akin to it being an attack on ISIS in Syria, it's a question of whether the political views and the legal views are necessarily at one. But at the moment, it's done under Iraq's right of self-defense and its extension of the NIAC in Iraq. Just to wrap up, because I know we're running out of time and you take questions. There are several issues that we're keeping an eye on, and I think in general, kind of Syria, people who work on Syria and watching Syria are keeping an eye on. And that's trying to make sure that we're properly and accurately understanding the nature of the NIAC or NIACs that are occurring inside Syria at the moment. The original NIAC was between the Syrian government and a large number, and an ever, in fact, increasing number at one stage, of anti-government armed groups. As the conflict in Syria has become more complex, there appear to have come into being several distinct, although sometimes overlapping NIACs. So, for example, there's a protracted conflict now between the YPG, Kurdish forces, and ISIS inside Syria, which is unrelated to the original NIAC, but occasionally overlaps. The second thing is that we're continuing to look at the foreign-sponsored armed groups and their potential to internationalize the conflict. So the question of whether this Syria's NIAC will turn into an IAC is something that is continually reviewed and looked at. as I spoke to before, the increased focus on ISIS in Syria seems to cut a little bit of the reasoning of the airstrikes as an extension of the airstrikes in Iraq. And then we also need to look at the legal implications of any entity, should any of the entities in Syria be recognized as attaining statehood with all its legal consequences. This is particularly the Kurds. I think this is highly unlikely, but it's something that we bear in mind. Should a state in Syria be recognized, the impact that would have on the classification of the conflict. So those are some of the issues. I'm sorry, I know that's a lot, and it's a lot to get through in a very short period of time. But I hope you found that useful, and I'm really keen to take your questions or answer any questions you may have.
Excellent. Thank you very much, Sarita. That was a very compelling tour of the factual predicate for Syria in just about 12 minutes, which is incredibly impressive. So thank you.
Yeah, I'm sorry. I hope that wasn't too, it felt fast. So I apologize to everyone if they felt that was a hurricane around them.
Well, thank you very much. And as Marcus said, we're just going to go a few minutes over if people presentations that they provided us today. And I would also like to remind those of you who are interested in undertaking the very brief assessment, the code is 5243. That's 5243 for those of you interested in taking the assessment, and that will be available immediately after the event. I would also like to thank the PHAP team. We have Marcus, of course. A huge thank you to Marcus. We have Saranjana Das, Katerina Luciani, and Helene Hamstra. And of course, the recording for today's event will be made available very shortly on the PHAP website. We hope to see you at our next event, which will be in August, where we will address the interplay between international humanitarian law and human rights. Until then, I wish all of you a good morning, good afternoon, and good evening.